Welcome to the Bankruptcy Matters interview series, organized and produced by the State Bar of South Dakota Debtor-Creditor Committee. In this series, you will hear from industry experts on the South Dakota bankruptcy process and how you can be involved in a growing area of the law. Please join us and our host, State Bar Past President Steve Huff, to learn more about why bankruptcy matters.
In this session of our Bankruptcy Series, State Bar Past President Steve Huff interviews South Dakota creditor lawyers Keith Gauer and Anthony Hohn on how they assist their clients in understanding the bankruptcy process and how they work with all involved in the process to reach the appropriate resolutions.
I would preface the interview by this morning, I always like to post things on Facebook that I find interesting or topical. And the ABA, I get their weekly newsletter, and I think you probably do as well. But they had a very topical story about the state of the economy and the demand for debtor, creditor, and bankruptcy related services. And so with us today are Keith and Anthony, two of what I would consider to be South Dakota's best practitioners in the area of credit-related services in the fields of debtor-creditor law and bankruptcy. And given that this article and frankly the last few years have shown that we need these kinds of skilled counsel and these skill sets, we thought it would be appropriate to talk about the area of law, what makes it work, and what is satisfying, as well as what is needed to develop these areas further. So with that, I would start with Keith and ask, what is the most important information you want from your client when a bankruptcy case lands on your desk or their desk and then your desk?
It's an interesting question, but I think the first thing that I want to make sure I have is a full and complete copy of the loan file, because at times bankers will try to piecemeal it to you, or they'll give you something that you don't need, or other stuff that what you really want, they have to go back and look for it. So that's always the first thing I ask for, is to make sure I have a full copy of the loan file. And I also ask the banker to tell me what's missing, what are the weaknesses here, what are our problems, because the banker sometimes knows, but they'll kind of try to hide the ball, particularly if they're the ones that made the loan. If there's a problem with perfection or otherwise, it's nice to have that up front and to emphasize the attorney-client relationship in terms of those communications, but establish up front that we need to know the facts. So that would be my sort of the step one with the bank client.
Anthony, how about you? What are your thoughts?
Yeah, I would agree with Keith on that. I would say another issue I like to talk to clients about is, what are your goals here? What exactly has happened pre-bankruptcy? And then in terms of the bankruptcy, what led to that? What's the relationship like between you and the debtor? And what do you hope to see out of this case? Are you hoping to get collateral back, for example? Do you want to work with the debtor and discuss what kind of repayment options there might be, talk about planned treatment pretty quickly if it's the kind of bankruptcy case that involves a plan. So I'd like to have those conversations pretty early on so that I have a good handle on exactly what the issues are and what the objective might be at the end.
Those are prudent suggestions. What do you think in terms of legal resources, not just in terms of legal research, but affiliations, some sort of continuing legal education groups? Do you find any of those that are particularly assistive in these fields? What do you do that at all, Keith?
Yeah, I'm a member of the American Bankruptcy Institute, the ABI, and it is a very good organization in terms of actual, solid legal research materials. They have a good website. They send out regular email missives, daily briefs on a case or two, and then they also have I think it's a semi-annual law review that has some real topical stuff. Frankly, it goes well beyond the practice of bankruptcy in South Dakota in a lot of respects, but there are some good nuggets in there as well. And then the other thing I like to use is the court's website with the decisions that Judge Nail and his predecessors have made, because those seem to be on point often with what the type of cases that we're seeing.
And Anthony, do you have any organizations or affiliations you recommend?
I would second what Keith said as far as the American Bankruptcy Institute. We get monthly newsletters essentially that are more than just newsletters. There's a lot of detailed analysis in there. And like Keith said, a lot of it deals with issues that we probably don't see much in South Dakota, but it's very good, very thorough. And this isn't limited to bankruptcy, but our firm does subscribe to the Clark's Secured Transactions newsletter. That it does have a lot of bankruptcy case reviews in there, analysis of different bankruptcy issues, and not just bankruptcy, but a lot of UTC issues, secured transaction issues that you deal with in bankruptcy and just standard commercial litigation. So that's really helpful. In Judge Nail's decisions, I always try to keep track of what happens, not just with Judge Nail, I guess, but in the Eighth Circuit, if there are any relevant bankruptcy decisions, it's good to try to track those and see what's happening as far as case law that might be changing.
Very good. So, and I think it might have been Anthony's comments on goals that kind of backdoored this question, but since bankruptcy rarely offers a win to one side or the other, how do your clients determine what is the initial or ultimately desired outcome in a particular debtor, creditor, or bankruptcy case, especially those that are more complex, whether they're actually filed or threatened Chapter 11s or Chapter 12s? Keith?
Yeah, Anthony, hit the nail on the head with that, in my estimation. That has to be one of the first conversations you have with your client and the creditor side. Virtually every banker, the first time they handle a bankruptcy case, comes in and says, I want to get out of this. I want all my collateral back, and I want it back today. And so when that happens, you have an education process that you're going to have to undertake to let the client know they can't in fact do that, and to go through the steps and what are reasonable outcomes for this type of case. And obviously that'll depend on whether you're in a reorganization case or a liquidation case. But it's important, I think, also upfront when you're doing that, to evaluate your collateral position right away. Get what the banker, the creditor, thinks the value of the collateral is, what we have for collateral, and then try to evaluate what reasonable expectations should be for the case. But to me, that's how you get to that compromise position when there really isn't a win in bankruptcy, or very rarely a win where you get the case dismissed and you get your collateral back and move on down the road. So,
something else I think is important to talk to clients about, and it depends who it is, depends who the client is, if they're familiar with the bankruptcy process, or if it might be something relatively new to that banker, to that creditor. But it's always helpful to talk about timelines, talk about costs. What exactly do we hope to get out of this? Like Keith said, do you want the collateral back? Do you want just to kind of wait and, for the most part, be cooperative with plan treatment or whatever it might be? But I always think it's helpful, depending on who I'm dealing with, to talk about, look, here's when a plan has to be filed. Here's when we have deadlines to do these different things, so they understand that and understand what type of cost might be associated with doing all the things they might want to do. But as far as what a win might be, it always depends on the case. So I think communication is helpful to explain what hurdles do we have to get to whatever objective it is that you want to see here.
Yeah. And I think that also alludes to the reason for asking the next question, which is, it seems like in this area, there are always a spectrum of creditor clients, some that are very sophisticated that you've represented before and have a great deal of knowledge and in day-to-day involvement in that area, to the newbie that may have never had a creditor related issue come up. And to that extent, I assume that means that you have clients that may or may not be up to changes on the law and what affects their day-to-day operations. Keith, do you find that your clients look to you for that, or do you find that the clients themselves are self-educated in the creditor and bankruptcy arenas?
For the most part, in my experience, if a client is self-educated, it's based on having handled a number of cases. I don't think I've run into too many bankers that have went to a bankruptcy symposium or received that sort of education. So typically the ones that have been around for a while and been around the block, they know what's going on. And the newbies, you have to spend more time talking to them, like we talked about originally. And one of the hardest things for me is when an individual calls and wants to talk about somebody who's in an 11 or a 12 and wants you to help them. It's just, it's very difficult because of the expense and time it takes to just educate them on what the reasonable expectations might be for that case. So those are difficult clients.
Anthony, how about your reaction as far as clients leaning on you or being self-educated?
Yeah, I would say it really depends on who your client is. Depending on who the creditor might be, sometimes they're very familiar with bankruptcy issues and they understand, relatively complicated concepts. So they understand how the process works. There isn't a whole lot of education that has to take place. But there are others, like Keith said, that are not as familiar, and that takes more time, and you have to explain what the bankruptcy code allows them to do, what the time constraints might be. If there are changes in the law, what I've done in the past is, it doesn't happen a lot, but occasionally if there are changes in the law, for me, it's as simple as shooting an email to the client saying, hey, this is what happened. This could affect our case. This is a new decision. We might have a stronger or weaker argument on this particular issue because of a new case we have. So it's kind of like any other area of the law. I think if the law changes, it's a phone call, it's an email, it's a conversation about how that might impact what you're doing.
When it comes to how you operate on a day-to-day basis, I assume, like I do, each of you lean pretty heavily on support staff. Did you come to have experienced support staff when you started with your current firm, or did you train that support staff in whole or in part? And if it was outside training, what was the most important training that those support staff received? Keith?
I think it's probably a mixed bag for both Anthony and I. I mean, we've each had secretaries, had new secretaries and assistants that help us with filing and maintaining contact with the court and things, and putting things in appropriate format. And I think, we pay attention to the training that the bankruptcy court provides, although a lot of it is probably more geared towards the debtors lawyers that have the high volume with the initial pleadings and the schedules and the like. But we focus on that, but I don't think, I think for the most part, we've ended up doing our own training as to what we need for bankruptcy work.
Anthony?
Yeah, I would just agree with Keith on that. I would say, one thing that I would recommend to anybody else looking to get into this kind of work is take advantage of what the court offers as far as training. Our local bankruptcy clerks and staff, they're really helpful. So what I've done when I've had new paralegals or assistants starting at the firm that don't really have a lot of experience with bankruptcy work is I will have them call over to the clerk's office and set up a time to go over there and do a one-on-one training session. And they're more than happy to do that over there. And that's very helpful in terms of understanding how to file things with the court, filing the notice of the motion, certificates of service, who needs to be served, timelines, things that are very complicated. They're not as standardized in bankruptcy court, as both of you guys know, as it is in circuit court or even in federal court for the most part. So I would say take advantage of that. I've done that several times. When there are group seminars that the court puts on, which they did somewhat recently, talking about the small business Chapter 11 subchapter V cases. I went over to the courthouse with my assistant and we spent a couple hours listening to the U.S. trustee and Judge Nail and the bankruptcy clerk explain changes in the law. And that's very helpful. I would take advantage of those things. That way you understand it and your assistant understands it.
That would lead me to a follow-up question. I'm going to guess that each of you had one or more mentors or people that you leaned on when you came to your current firms that you were able to obtain information from. And I assume the kind of training Anthony described is like that you got in-house from people with more experience. Is that a fair assessment, Keith?
Oh, definitely. Definitely. I spent a lot of time in Bob Hayes' office asking him questions. And, I've also consulted with the lawyers outside of the firm as well that are, practice bankruptcy. It's a pretty small and a pretty collegial bar. So if somebody was new coming in, it would be important to reach out and at least, make those informal contacts and have a base on which to rely on for questions and the like.
And I think, Anthony, if I understand correctly, you've had several different mentors throughout your career. Is your experience the same as mine and Keith's?
Yeah, Steve, I would agree with that. I mean, I haven't been doing this nearly as long as you or Keith have been. So I've really relied on, Keith, for example, still is a mentor to me in terms of a lot of the issues that come up with bankruptcy work. Bob Hayes in our office. And I also want to echo what Keith said. I have, I wouldn't say frequently, but I have on occasion reached out to attorneys at other firms that do this kind of work. And, one nice thing about the bankruptcy bar, in particular the creditors bar, from my perspective, is that everyone's willing to help. And if you have issues come up that you aren't familiar with, I've had a lot of help from other people inside my firm and outside.
Yeah, I'm very much in the same mindset as you both on that point. Without saying your particular hourly rate, I think we learn, because the bankruptcy process is partially open and rates are typically approved, what the hourly rate of creditors are charging. And do you see a range of those rates? Have they changed recently? And most importantly, do you provide services in some cases at flat fees or contingent fees, or do you typically do so within that range of hourly rates? Keith?
Last question first. I mean, we're primarily an hourly rate shop, although we do have some national clients that will do real limited scope work on a flat fee basis, like lift stay motions that are uncontested, as an example. But otherwise, we're an hourly rate firm. It does seem to me, I mean, there's a pretty wide range, probably from the high hundreds to the low 400s and $1 per hour in terms of range of creditors lawyers. And, when we get these larger cases in the state and we have people from Minneapolis or Omaha come down, that range is probably closer to $500 on the high end, and maybe even higher, depending on where they're coming from. If they come from Chicago, it's probably $600-700 an hour. And the court has, to my knowledge, not pushed back too hard on those, although I'm not sure that's ever really been asked either. So that's what I've seen.
Anthony, how about you? What have you observed on the issue of rates?
Yeah, I don't have a whole lot to add to that. I mean, as far as lawyers in South Dakota, and Keith is exactly right. Some of the lawyers from bigger cities and metropolitan areas outside of South Dakota usually have much higher rates. But, from what I've seen, it's, between 200 to 350, 375, it seems like, for South Dakota lawyers that practice in this area.
Yeah, the highest I've observed, and typically in bankruptcy, that gets disclosed more than in the private sector in federal or state circuit court litigation. But the highest I've ever seen is 625 for out of state counsel, and I think the lowest that I've seen in the last 2 years is 175. So that's kind of the extremes on the spectrum that I've seen. But I believe your estimate of those rates typical to South Dakota is accurate, and it's different, it seems, if you look at Sioux Falls or Sioux City or even Rapid City versus some smaller, more central or rural locations. So that always seems to impact the business to a certain degree. Tell me a little bit, Keith, about what aspects of being a bankruptcy attorney have you found to be most challenging, and how you address that?
I think that the hardest thing about bankruptcy, in my mind, it's a national code, but bankruptcy courts across the country interpret it a little bit differently. There are some local institutional knowledge that you need to get. And then the hardest part on that is that, South Dakota is a low volume case state. We don't get hundreds of Chapter 11s every year. We might have a handful, usually less than 10. And so it's difficult to gain that experience, and oftentimes you'll be seeing an issue for the first time. So I think that's one of the more challenging things in South Dakota in terms of the practice. And to address that, you just have to rely on the resources between what you can look up on Westlaw, what you can look up on the American Bankruptcy Institute's website, and what you can confer with your partners or others about how to handle things. So that would be my thoughts.
Anthony, how about you? What are your observations on what's most challenging?
One thing I would say is bankruptcy cases are a lot different than your standard lawsuit in state court, for example. And I've done a lot of that in my previous life as a lawyer, different kinds of civil litigation. And those cases can drag on for years, and you might not have a deadline that's 10 days away or 20 days away when the file comes in the door. Bankruptcy is just a lot different, which can be really good because you can reach a conclusion to a case relatively quickly depending on the kind of case it is, and you can see progress and you can get your client some sort of resolution typically pretty quickly. That's not always the case with a typical car accident case or personal injury case or whatever it might be. So that's a good thing. But one of the challenges that comes with that is having to stay organized, stay on top of exactly what's happening in a particular case. You have deadlines that can come up very quickly. You might get a cash collateral motion and you have a very short time frame to get with your client, go through a lot of information and figure out, what do we do about this? And do we file an objection? Do we try to negotiate some kind of a resolution? So as both of you guys know, that's one challenge I see is you just don't have a near unlimited amount of time to figure something out. So you do have to stay organized. You have to make sure you're on top of what's happening in a particular case. So that's been, for me, it's just a lot different than a typical civil case. And also, depending on the kind of bankruptcy you're doing, the volume of just what is happening at any particular time can be a challenge. And then there are other times where nothing's really happening in a particular case. But if you have 3 or 4, Chapter 12 cases or a couple Chapter 12s and a Chapter 11, and everything's happening at the same time, you just have to stay organized and stay on top of each case.
Well, I want to thank both of you very much for your assistance and time. But before I let you go, I've got one last question for each, which is what parting words of wisdom would you offer to any attorneys either considering a career in debtor, creditor, or bankruptcy work, or considering coming back to this area of law? Keith?
For a new practitioner, I'd just say read the code. You'd be surprised at how many little nuggets are in there. Even after you've been practicing it for a while, somebody will come up with some subpart of some section that you thought you were familiar with that you had never heard of. That happens on a regular basis, even for people who have been practicing it for 20 years. So that would be my nugget of advice for a practitioner coming in.
Anthony, how about you?
I would say from my perspective, someone that did not start out in this area and I kind of fell into it, for me, advice I would give somebody else would be patient. You're not going to jump into representing creditors and understand every nuance right away. That's just not how the law works in really any area, in particular doing bankruptcy type work. So be patient, but don't be afraid to reach out to other people with more experience for help.
Well, I again want to thank both of you for your thoughts and your eloquence for assisting in this project. If I could ever repay the debt that you've allowed me to incur with some sort of reciprocation in the future, I would sure like to do that. And with that, I would end the interviews and thank you again for your time and your support for the State Bar. We appreciate it.